For those with serious mental illness, a balance must occur between individual rights, individual safety, and society's right to safety and security. These factors may not always align exactly. Let's examine civil commitment, criminal commitment, and patients' rights in the context of mental health services. Civil commitment laws guide the legal declaration of mental illness and outline when a person can be placed in a hospital, potentially against their will, for treatment. The laws and definitions of mental illness vary by state. In general, the criteria for civil commitment include the following: a mental illness that needs treatment, danger to self or others, inability to care for self. Let's examine each criteria further. Civil commitment process. In order for the civil commitment process to succeed, a person must fail to seek help for a mental health issue where others feel that help is needed. A petition is made to a judge on behalf of the person, while the individual in question must be notified of the commitment process. Most often, the process includes normal legal proceedings to determine if a person should be committed. The decision is then made by a judge and informed by expert opinions. Mental illness is not synonymous with a psychological disorder. Let's analyze the legal concept of mental illness. Legal concept of mental illness. Mental illness is a legal concept that involves severe personal disturbances. Some mental disorders, like intellectual disability and substance-related disorders, are often not considered mental illnesses by law. This presents challenges to processes between the mental health service and legal realms. Assessing dangerousness. Assessing the dangerousness of an individual remains the role of mental health professionals, and there are common misconceptions that people with mental illness are much more likely to be dangerous. This can be perpetuated by sensational media portrayals and can also lead to ethnic minorities being seen as dangerous. While dangerous and publicized criminals, namely serial killers, are often living with mental illness, the fact is that the vast majority of people with mental illness are not dangerous. Modifications to the law. Early Supreme Court rulings in the process of civil commitment placed restrictions on involuntary commitment and stated that the need for treatment alone is not enough to warrant commitment. Some consequences of those rulings included the criminalization of the mentally ill and an increase in homelessness, deinstitutionalization, and transinstitutionalization. Subsequent modifications to civil commitment procedures were broadened to include involuntary commitment for individuals who were dangerous and non-dangerous, as well as for those who were in need of treatment. Criminal commitment involves being accused of committing a crime and being detained in a mental health facility for evaluation. The focus is on fitness to stand trial, with possible outcomes being guilty or not guilty by reason of insanity. Let's examine the insanity defense and other concepts related to the criminal commitment process. Insanity defense. The insanity defense is frequently portrayed in popular media, but is actually very rare and is used in less than 1% of criminal cases. The insanity defense plea is a legal statement, and if found not guilty because of insanity, the defendant is sent to a treatment facility rather than prison. It is not a legal loophole that lets someone off of the hook for a crime they have committed. Not guilty because of insanity involves the following: inability to distinguish right from wrong. Crime is a product of a mental illness. Inadequate self-control. Diminished capacity. Competence to stand trial. For those who are charged with committing any crime, the requirements for competence to stand trial include understanding legal charges and the ability to assist in one's own defense. When an individual is found to be incompetent to stand trial, he or she loses decision-making authority and may be committed. In civil and criminal proceedings, a psychologist, as expert witness, provides specialized knowledge and expertise. Experts can assist in competency determinations, making reliable diagnoses, advising the court, and assessing malingering. Duty to warn. Mental health clinicians, outside of a legal or court setting, also have a duty to warn and are mandated reporters if they become aware of imminent future or ongoing danger. Failure to warn could result in the loss of life, as documented in the Tarasoff versus Regents of the University of California case. Patients cannot be involuntarily committed without treatment. That treatment must be within the least confining and limiting setting, also known as the right to the least restrictive alternative. Patients also have the right to refuse treatment, and this is often the case involving medical or drug treatment. For research participants, informed consent must be provided. Research participants have specific rights. Research participant rights: privacy, to be treated with respect and dignity, to be protected from physical and mental harm, to choose or refuse to participate, anonymity in report of study findings, safeguarding of records.